Mr. Bahari-Lau.
My Lord. My Lord.
You were all wigged and gowned today.
Yes, courtesy of Mr. Nibar, who appears for the respondent from Trinidad, would wish to appear in robes, and I'm happy to do so. My Lords, there are a few documents that you've had extra, in particular, a fresh set of reasons from the Court of Appeal, which were issued last week, Friday. We've provided hard copies of that, as the registry requested us to do, so there's a small further bundle you will have on your side table, which includes a hard copy of that judgment, but I'm told that some of you may have seen that electronically already, because it was sent.
Yes, we have.
Yes, thank you.
My Lord, I'm going to try and, I will keep to my speaking time, even dealing
Oh,
with
you
that.
keep to much less than your speaking
I
time.
suspect so. My Lord, this case is a good example. Forgive me, I should have said Mr. Hitchens appears with me for the appellant. This appeal is a good example of the consequences of parties failing to consult a conveyancing attorney before entering into contract. But that said, what doesn't appear to be disputed is that both parties knew that planning permission was required, and neither party incorporated that into the contract. Of course, the board knows that the judge preferred the respondent's version of the agreement, which did not include any express provision for planning permission. In terms of the judgment that, forgive me, the fresh reasons we've received, we've provided a statement from Mr. Pariag Singh to explain how that arose. I'll take it shortly, but essentially it looks like the Court of Appeal may have misunderstood what was being asked. We understood, and it's normal practice, that when an extemporary judgment is given, if it is to be reduced in writing, it's simply put into the standard format with the heading and so forth. Instead, we have a fresh set of reasons, and we are going to invite the board to disregard them, and we say that that is the only proper course. The reasons we say the board should disregard them is that, first of all, it's the epitome of unfairness. It doesn't address the reasons the Court of Appeal gave in its extemporary judgment, implying a term in law, and it does not expressly state that it was wrong to have done so, which must now follow from what it says. In addition, specifically, it didn't address the relevant part of the High Court's judgment where the trial judge gave clear reasons as to why she was implying a term in law. It simply ignored it and instead simply refers to it now as an implied term. One assumes changing the position from an implied term in law to an implied term in fact.
But is this a case of implied term at all?
Well, my Lord, we sought leave on the basis that it was an implied term in law. That's the approach adopted by the High Court and the Court of Appeal, and we said that it shouldn't have been implied in law, that there was no such term, and in short, that the contract being silent on that, there was no onus on the vendor to apply for planning permission, and so to hold him liable on that basis was wrong.
But if the vendor has an express contractual obligation to convey on completion and upon the receipt of the purchase price, to convey the property agreed to be conveyed, and is under a statutory disability because there is no planning permission, why isn't the vendor simply in breach of the obligation to convey? Why does implied terms come into it?
Well, my Lord, the way in which the courts below approached it was to say his failure, his breach, is the failure to obtain planning permission, which leads to the failure to convey.
I understand that, but ultimately this is a question of law.
Yes.
And my question to you is, why isn't the breach constituted by A, the vendor's failure to convey to the purchaser, and B, the vendor's conveying the property off with other property to somebody else?
Well, my Lord,
I mean, and that's all within the express four corners of a contract for sale, properly understood?
Well, my Lord, it puts me in a difficulty because, of course, we say that the trigger for this breach is the implied term in law, and that's the argument we've sought to make from the beginning, and it's the argument I seek to persuade the board to accept. My Lord, in relation to the Court of Appeal's judgment, again, we say that it ought to be disregarded. We say that effectively for three core reasons. Firstly, the court gave reasons in February 2016. By the time Friday arrived, it was functus. and the appeal is now to be determined by the board. If it were a judicial review case, I would say that they probably acted beyond their powers. But secondly...
I mean, does it matter? I mean, we have their reasons. I mean, either they're good or they're bad. Do we need to spend a long time worrying about whether we can look at it?
Well, my lord, we say it's important because we say it's irregular. And if and insofar as this type of thing could likely happen again, we would say that the board should expressly deal with it. And I'm going to be brief, but I don't think the legal principles involved have been specifically considered by the board. But they do arise now, and I would like to just briefly...
Well, your point is that the Court of Appeal shouldn't have the opportunity to present new reasons for their decisions.
Yes, and it's a different matter entirely. My lord, can I invite your attention, please, to... I think there's a further authority.
That's possibly rather short of saying that we should disregard what they have said. And obviously, what they have said, whether it represents their views originally, may well be relevant to the resolution of the appeal.
Well, my lord, I am concerned that we've been
being the final Court of Appeal, we're not bound by technicalities such as whether or not these are factors which were present to the mind of the Court of Appeal at the time. They may influence our decision as to the outcome of the appeal.
Well, we say, my lord, and that's exactly why, my lord, I say that you should disregard it, because we say it should not influence the board's decision now. But may I take it briefly? I said I would, and I would deal with it. Could I invite my lord's, the board's attention to ex parte input management? I think that's a... is that behind us?
Do we have this electronically?
You received it electronically.
Did we? I'm asking you.
It was sent, but we've got hard copies just in case.
Well, what are we looking at?
It's the decision of Crown versus Crown Court at Snaresbrook, ex parte input management. And it's the ex post facto rationalisation point, which we say the Court of Appeal, fresh reasons, relates to. Could I invite the board to look at paragraph, page 6, sorry.
Thank you.
And it's the quote from ex parte Cook, which is the indented paragraph. And it's the middle part of that paragraph. It's plainly fair that an appellant should know as soon as may be and reasonably contemporaneously what the reasons for a decision are. Contemporaneity is important in order that the appellant may be assured that there is no subsequent rationalisation. And then, skipping to the next paragraph, if reasons are given properly and at the conclusion of the hearing or soon thereafter, then the appellant or respondent has the opportunity to consider his or her position to decide whether, for example, an application to state a case, we would say whether we should apply for permission to appeal, and cannot entertain even the suspicion that there has been some ex post facto rationalisation going on in the preparation of the reasons themselves.
But it often happens, doesn't it, that a judge gives a judgment extempore, orally, and then receives a transcript, and then realises that it's necessary in order to express his reasons, his or her reasons, to put in more facts, provided that they don't depart from the essence of what they decided and gave the reasons that they gave orally. That's perfectly in order and acceptable.
It's perfectly acceptable if it follows relatively shortly after the extempore.
Well, why does it matter if it's short? Because very often, and this is a practical point, you will not be asked to approve a transcript until many months, sometimes even years. I was asked 12 years later to approve a transcript of an oral judgment because people don't realise that there's something in it they need to have recorded. It just happens that way, but it's not improper of a judge to correct a transcript in the way that I've described. So it couldn't be proper where you've given reasons to express them more clearly. It's where you have a discretion and you suddenly decide to exercise it on completely different grounds. You can't do that.
Well, yes, and I agree.
There are limits, but no, you're not suggesting that happened here.
Well, Milady, we are suggesting that happened here because the language used in the written reasons which we now have is different in terms to the written reasons that were given by the Court of Appeal in the extemporary judgment, and in fact when they considered what the judge herself did. And we say that this is a classic example of ex post facto rationalisation, where having been asked simply to provide a formal judgment of what they'd said earlier, they've now shifted the ground. If we had had that set of reasons, the appellant may have received different advice. It may have influenced how we phrased our grounds of appeal when we sought special permission.
I mean,
from
why
the
does
board.
any of this matter? Right, I'm sorry. You know, as you said, there was obviously a misunderstanding here. They thought they were being asked for something and they weren't. And now we've got it. And either it's good or bad or indifferent. But why should we be asked to lay down general principles to deal with something which appears to be a misunderstanding, but doesn't in any way prejudice you, because you can deal with whatever the grounds are? I mean,
My Lord, we
we're
do
here
say,
to decide what the answer is, not...
we do say we are prejudiced. Of course, we'll address them to overcome that prejudice, and that's what we intend to do. And that's why I'm drawing the board's attention to these matters.
Mr. Barrowlough, one other question on
Yes.
this. An appeal court can always ask a judge to amplify reasons, isn't that right?
Yes. And normally that would follow, following the hearing of the appeal, where an issue may arise that the Court of Appeal is concerned about and says, well, I would like further reasons on this particular issue, or direct a further hearing to resolve a specific issue. There's express provision for that in the Supreme Court of Judicature Act. But what we say happened here is not that. This was not a request by the board for specific reasons or to deal with a particular issue. This was an administrative error which ought not to influence the board, where we have sought leave and been granted that leave on a particular basis.
Well, I
That
think
is
your
what we say
point
we're
really
prejudiced.
resolves to this. Of course, the Court of Appeal can amplify its reasons and explain why it reached its conclusions, but it can't change the reasons for reaching the judgment, and that you are disadvantaged because the reasons which you say are different from those which motivated the Court of Appeal were not ventilated in the hearing before the Court of Appeal. You
Yes.
didn't have the opportunity to meet them. But I have to go back to my original point, and that is we have to consider the matter afresh. And if these are reasons which are significant as to the outcome of the appeal, we've got to consider them, because we're the final Court of Appeal and we're not bound by the way in which the case has been presented by the parties, nor indeed by the way in which the decision has been reached by the Court of Appeal.
My Lord, I know that the board's jurisdiction is, in that sense, is not limited. I'm not suggesting that it is.
Yeah.
But what I'm suggesting is that this was irregular in the way in which it occurred based on a misunderstanding. Had it occurred because through a formal request and we got exactly what we asked for, that's a different matter. But in any event, I'd like to deal with the point, and of course if the board considers that it will not deal with it in its judgment.
We may well consider it's necessary to deal with it as a matter of formality, but I think we've probably exhausted that point, haven't we?
My Lord, can I give you the references? Because we did spend a little time trying to address this when we received it on Friday, and
Yes,
I'll give it to you. We've also relied on the very well-known case, the principles which are applied in Trinidad of English versus Emery-Reinbold. We've again provided a hard copy of that, and it's paragraph 6, which is the relevant paragraph, we say. And again, taking it shortly, the duty is a function of due process, therefore justice rational has two principal aspects. The first is that fairness requires that the parties, especially the losing party, should be left in no doubt why they have won or why they've lost. This is especially so since without reasons the losing party will not know whether the court has misdirected itself, and thus whether he may have an available appeal on the substance of the case. And this is why I've laboured, I hope not too long, the basis upon which we sought leave. Paragraphs 18 and 19 are relevant to the appeals process and may be relevant to my Lord Kitchen's question to me. It's paragraph 18 and 19 of the judgment. When considering the extent to which reasons should be given, it's necessary to have regard to the practical requirements of our appellate system. The judge cannot be said to have done his duty if only after permission to appeal has been given and the appeal has run its course, the court is able to conclude that the reasons for the decision are sufficiently apparent to enable the appeal court to uphold the judgment. An appeal is an expensive step in the judicial process and one that makes an exacting claim on judicial resources. For these reasons, permission to appeal is now nearly a universal prerequisite to bringing an appeal. Permission to appeal will not normally be given unless the applicant can make out an arguable case that the judge was wrong.
Well, we're here now. Yeah.
Which short circuits completely the submission I'm making. And again, paragraph 19, it follows that if the appellate process is to work satisfactorily, the judgment must enable the appellate court to understand why the judge, in this instance the justices of appeal, reached their decision. And I won't go to the rest of the paragraph, but we accept, as I've accepted in appeals before, it doesn't require a lengthy judgment as long as we know why they have decided what they've decided and what they've considered. And that, we say, was clear from the extempore judgment. It wasn't necessary to elaborate. I'll give the board the reference to the next case, but you have a copy of it. It's Garth Jeffrey Waymont versus James Robert Place, and paragraph 6 of that judgment. And it may bear on the question my Lord Kerr asked me a moment ago. Within the bounds the parties are entitled to have explained to them how the judge, just Court of Appeal we say in this case, has determined their substantive rights, and for that purpose the judge is required to produce a fully reasoned judgment which does so, applying English.
That doesn't deal with variation.
No.
Or addition to a judgment.
Precisely. And so you can give more reasons to justify what you've said, cannot change the substance of what you said and the basis for it, or what you've considered. We say that is what happened, and could I invite my Lord, since I've got to deal with it, and as my Lord said, we're here now, could I invite you to look at the Court of Appeal's Fresh Reasons, paragraph 37, which is the last page. And it's the final paragraph. For these reasons we dismiss the appeal. So they are saying that these are the reasons that they dismiss the appeal. But we know that that is plainly wrong. More so, we know that it took into account matters it assumed were before the board, but were in fact not and are not before the board. And if I can illustrate it by referring to the record, if you turn to page 372 of the record, sorry, forgive me, 349. This is the order by the board granting permission and on some grounds and refusing on others. And if you look at paragraph 2, the board will see that permission was refused specifically on grounds 1 Roman numeral 3 and 2 Roman numeral 6. Then if you turn to page 371, which are the grounds of appeal upon which we obtained, we sought leave, you will see that ground 1 Roman numeral 3, and then on the next page, ground 2 Roman numeral 6, were grounds relating to the waiver point, on which we did not get leave, and that's why we've not dealt with it. So where the Court of Appeal reasons at pages 12 to 13, paragraphs 34 to 36, concerning waiver, those were wrongly considered in any event. It was not before them and it's not before the board. Why the error occurred has been taken from the summary, which is provided on the JCPC website, and it's been treated as giving the Court of Appeal a formal basis for giving reasons. And this, we say, my lady, it goes further than what was before them.
If they had simply said, for these additional reasons.
Well, then it would, but again, they then need to explain the contradiction insofar as we say there is one with the extemporary judgment. So if they're saying, well, look, for these additional reasons we have now changed our mind, or we accept that there's no implied term in law, then that may be a different matter. But we say that that is not this set of reasons. This is a completely fresh judgment, in effect.
Which particular paragraphs in the judgment?
It's paragraphs 34 to 36. Which is on page 12. Correct.
But those are not relevant to us because we're not going to be dealing with waivers.
No, I agree.
Well,
I agree. But this is why we say that these are irrelevant considerations taken into account. And I've already dealt with how it arose and looking at the JCPC website. And we would say, at the very least, my lord, the Court of Appeal ought not to be looking at a public website for information as to how to give further reasons. There should be a degree of formality which may go to a particular issue.
But the ultimate point is this, surely. If we believe that reasons now given by the Court of Appeal are pertinent to the disposal of the appeal, we should not be shut out from considering those simply because they differ from the original reasons. I mean, we're the final Court of Appeal here. We've got to look at all of the issues that obtain. And as it happens, some at least of us consider that the whole issue of implied term is perhaps not central to the outcome of this case. And therefore, the circumstance that the Court of Appeal has given different reasons from those that originally actuated them is neither here nor there.
Well, my lord, I take on board what you're saying, but we maintain our submission because of the
I think we've got the message that this is irregular. And
it's irregular, but there's one more element to it, which I'm hoping will interest the board in relation to the fresh reasons. It's one matter.
You say interests the board, Mr. Behan.
I'm very grateful. It's a specific matter in relation to error. Matters which were not argued before them or were argued before them. Could I invite you to look at paragraph 16 of the fresh reasons? Where the Court of Appeal state, before this court, the issue is not dealt with in written submissions, but was raised by the court during the course of oral submissions. This is in relation to the implied term. We say that that is plainly wrong, and we can demonstrate it as such. If the board looks at page 311 of the record, bottom of the page, this is the skeleton argument for the appellant in response to the respondent's skeleton argument. And it shows expressly that the express term of the written agreement and the implication of the obligation on the vendor was expressly dealt with. And then if you turn to page 314, top of the page, the issue is again addressed in submissions, addressed differently to the way we have, but addressed nonetheless. So those errors, and they are errors, we say, because we can easily demonstrate them, go to the purpose and the issues in the appeal before them, and now...
I beg your pardon, which page?
314 is the second page. This is reference, my lord, to the skeleton argument before the Court of Appeal.
Thank you.
But what turns on that?
To say, well, I answer my lady directly. To say, therefore, well, it wasn't before us, we didn't have the benefit of written submissions, it only arose in oral submissions, in fact, is wrong.
But what I'm asking you, what turns on it being
What
wrong?
turns on it is that they have proceeded on a false premise.
Well, but does it have any implications for the point of law we have to determine?
Well, it does if the board wishes to take into account the reasons which have been given.
Yeah.
And I'm just completing that point, that here we have a judgment which is dealing with a series of matters and actually misconstruing what took place before it some 3 years before. Perhaps as good an example as any as to why it ought to be reasons given shortly after the event. We say it is unfair, and for that reason we invite the board to disregard it. My Lord, in relation to the primary issue, notwithstanding my Lord Kerr's question about
No,
the certainty of the
you've
implied
made your
term of
position
law,
persuasively clear.
and I hope brevity is something that's favoured. In relation to the implied term in law, we say that there is a specific problem with the actual term. It's one thing to say an applicant must, or a vendor or a party, must apply for planning permission, but the way this was construed is that they had to obtain it. And we say that that was simply a term that could not be implied, whether in law or whether in fact. And in terms of how that happened, we say that that's unanswerable. We say it's unanswerable because when you actually look at how terms are implied, and there's no dispute about the law in relation to implied terms, it's not enough that they're reasonable, but they should not be unreasonable or impossible for a party to comply with. The law will not imply a term in that circumstance and would not have implied a term, we say, in relation to saying a party, whether vendor or purchaser, must obtain. They can apply, they can fail, but then that's as far as it goes. The Court of Appeal and the High Court dealt with it in that way. In terms of whether an implied term is operative in the appeal, I'll deal with that straight away.
We now move beyond.
We're now moving. I've dealt with what we say is the ex post facto rationalisation.
Yes, we're now dealing with substance.
Moving to the substance of the appeal and dealing with the two specific disputes between the appellant and respondent on our cases. Was there an implied term in law, which is why I say that that's the question being put? And secondly, was planning permission or outline planning permission ever granted to the respondent for the subdivision of 8 lots? Dealing with the first question, it seems, and I address it now because I know the board will have regard to it for any assistance. The Court of Appeal, page 9, paragraph 26, we've already looked at it, appear to concede that there is no direct authority for an implied term in law. But what they do seek to do is radically change the ratio of its extempore judgment by implying a term, it seems, in fact, rather than law. And as we said, that's a U-turn. But we say we can demonstrate quickly that it was a term implied in law. And if the board turns to the record, page 178, this is the judgment of the judge. The trial judge expressly considered Section 4 of the Conveyancing and Law of Property Act, that's the standard statutory requirement for a contract for the sale of land to be in writing, and the compliance with that section. And then if you move down, it's bottom of the page, page 178, the judge expressly considers to comply with the statute, the memorandum must evidence all the material terms of the contract. And then it goes over the page to point number 4, any other material terms of the contract except as would be implied in law. And the way in which the judge deals with it, the next paragraph, I'm sorry, it's not numbered, but it's the very next paragraph. Insofar as securing planning permission is concerned, it would seem to me that this falls within 4 above. In my opinion, there is implied by law the responsibility of the first defendant to obtain, emphasis the word obtain, the relevant planning permission for the subdivision of land by virtue of the requirement for approval for any subdivision of land in the Town and Country Planning Act. And the fact that he sought to sell the claimant a piece of larger parcel of land, which piece of land was to be divided into lots of a specified size. More to the point, this was done in direct answer, we say, to the appellant's argument, which is that, I think it's summarised here, it's the second line on the top of page 179. The defendants submit, however, that two terms are omitted from the written agreement, the first being that the first defendant was to secure planning permission. So it's clearly operative, and that submission having been expressly and deliberately considered, it could not be clearer that the judge considered the fact that the memorandum did not contain an express term and then sought to fill the gap, so to speak, with the implied term. Secondly, Court of Appeal, page 344 of the record. And this is helpfully numbered, line 3, where the Court of Appeal says, we agree with the judge that it is a term that, in any event, would be implied by law, and we think that the way the judge dealt with it is correct. And then they go on to explain why they decided the judge was correct to imply this term, going further and saying, in that it is the obligation of the vendor to show or to pass a good marketable title, and if the law provides that land is not to be subdivided unless permission to subdivide is first obtained, then it seems to us that that goes to the ability to pass good marketable title, and in the absence of a contrary agreement, that must be on the vendor to obtain that permission. Thus, we say it's beyond doubt that both the High Court, Court of Appeal, implied a term in law. And that
Except that the
ratio of the decision.
This passage by the Court of Appeal
Yes.
says that this really flows out of the obligation to pass a good title. So that if you agree that you're going to convey and that you have title to convey property to somebody else, any inhibition on being able to do so is something which you, the vendor, have got to deal with. I mean, take a restrictive covenant, whereby there is a restrictive covenant against conveying part. So it has exactly the same effect as the planning regime, but it's a traditional restrictive covenant of the type which perhaps is more familiar, at least to us, than a planning restriction on conveyance. If a vendor simply contracts to sell, and there is a restrictive covenant there that prevents him selling, he's got to get rid of the restrictive covenant. He doesn't just impliedly agree to try, he's got to get rid of it, or he's in breach.
In terms of
in other words, it's got nothing to do with an implication of a term. It's a conditional contract. He's got to get rid of, as my Lord says, the restrictive covenant.
well,
Likewise, your client has got to get rid of the inhibition on his ability to sell.
Well, my Lord, I am going to deal with it. I'm not sidestepping it, but it was going to be the last topic, conditional contracts, that I was going to deal with.
May I say, just so you understand where I'm coming
Yes.
from, I don't have it in mind it's a conditional contract in the sense that if he can't, the contract goes off and all the purchaser gets is his purchase price. I'm looking at it in terms of the vendor being in breach.
Understood that.
End of story.
Can you just, I mean, where it's unfamiliar to us to have a planning requirement against subdivision, where does one find that?
If you're, I can take you to that now. If you go to the authorities bundle, and it's the Town and Country Planning legislation. I think it's with me. And it's 724.
This is a definition of development.
Yeah, control of development of land, section 8.1, subject to the provisions of this section and to the following provisions of the Act. Permission shall be required under this part for any development of land that is carried out after the commencement of this Act. And if my Lord looks at subsection 2, subdivision.
Yes, so the development is not just what we would recognise, building and operations and change of use, but includes the subdivision of any land, except certain operations. Yeah, thank you. So
that just finishing that particular topic, that's why we say it was implied in law expressly and by the courts below. My Lord, I'm going to move from that to the issue of planning permission, but before I do, I don't know whether my Lord or my Lady would wish me to deal with any of this.
For my part, could you please just show me the contract?
Yes, it's...
In the version found by the judge, too.
Yes. Just bear with me a moment. I think
As opposed to the amendment.
if my Lords go to page 7, and it's page 20 of the record. Although, my Lord, we've used the phrase contract and so on, if accepted, it's a memorandum that would be sufficient for section 4.
Yeah.
So page
Page 20 of the record.
Okay.
This is the respondent's version of the that was accepted by the judge.
And these lots are defined where?
If my Lord has, I think we've taken it out of the record. It's actually in there, page 255 of the record. We've put a hard copy on the side table. The lots that are referred to are, if I hold it up like this, with the Thompson Trace Road to my left, it's the 4 lots either side of the road reserve, towards the back. 1, 2, 3, 4, 5. So, in other words, lots 4, 5, 6, 7, 8, 9, 10, 11.
Thank you.
Yes.
Mr. Behar, on page 21, there's the sentence, the above land has a good marketable title to the said premises, free from etc., etc. And that works as a warranty of title, presumably, in Trinidad and Tobago.
Well, certainly we accept. There's no dispute about this, my Lord, having
That's what I thought, but I just wanted to clear it up.
The vendor must show good marketable title to the purchaser before completion. Before, for example, he can issue a notice to make time of the essence and so forth. So we accept that, and we don't go behind the representation that the property has good marketable title.
But that means both that the vendor can lawfully convey the title and that upon receipt by the purchaser can lawfully convey it.
Well, my Lord, the way in which I'm going to deal with it, yes, I accept number 1. Number 2, we say that we showed good marketable title to the property because there was nothing restricting us from selling our own property. Once we had shown, we'd paid the taxes, we'd got the certificate of title, and so forth. We say, although how I'm going to deal with it quite, is that good title was shown.
But if you can't subdivide, how can you say you've got good title to the property you're trying to sell?
It may be that I'm not going to get far with the submission, but we say that goes to conveyancing rather than title. But I'm going to try and deal with that.
Because it's good marketable title.
Yes.
No, but I mean, it must be quite an important point of Trinidad laws.
Oh, yes. Oh, yes.
Is it not something that's come up before?
Well, my Lord, what has come up, and I say that because I can't recall, I think my Lord appeared in Munglesing and Juman, but what was established is that contracts like this, open contracts, if you like, are quite common. And good marketable title has to be shown by the vendor.
Yes, but what I don't, in a situation where you're subdividing and where it's known to everyone that subdivision requires permission, how does that affect your obligation to give good marketable title?
Well, I'm coming to deal with it, but if I can give the short answer to my Lord now, we say that where the contract is silent on that issue as to who has the obligation to obtain the permission for subdivision, that would ordinarily be caught by the rule caveat emptor, that it is the purchaser who must make these inquiries and make such application. Now, it's a short submission, but can I get there?
You say that, but
yes.
There's no authority at all on this.
It doesn't appear to have arisen in anything we have looked at. This case that we have before the board appears to be where it's been first considered.
Can I just ask, if you had a similar memorandum and the problem was a restrictive covenant to which the memorandum made no express reference, are you saying that's caveat emptor?
Well,
The restrictive covenant being one which stops you conveying?
I haven't specifically considered restrictive covenants. But
I'm just trying to use it as a sort of...
No, absolutely. And
The problem we have, Mr. Harrow, because is that we are personally, as it were, unfamiliar with a planning restraint on conveyance.
yes.
So that it's dealt with in English conveyancing, if there are planning problems, in a completely different way, because it doesn't go to conveyance, the ability to convey. So I just thought the restrictive covenant might be a sort of more convenient analogy.
It may be, my lord.
And you can tell me why it's not a suitable analogy.
Would your lordship give me a moment to think about
Yes.
that while I make the other submissions?
Sure.
I'm moving Sorry.
Just before you go on, if one doesn't gain the relevant permission, what is the effect on the agreement? I mean, is the purported transfer invalid or what?
Well, we would say that I'm sort of, as I said, I was going to deal with this towards the end, but essentially, where you don't have that critical term included in the contract, it doesn't form a binding contract, because that term as to who is to obtain planning permission, as we say in this case, if there was no provision for it and it couldn't be implied in law, then that condition precedent, so to speak, that this had to be done, meant the contract was not binding.
I wonder if my lord's question was aimed at this problem. Assume that, blithely disregarding your planning obligations, or somebody's planning obligations, the vendor just conveys these parts to the purchaser. That the planning law doesn't make the conveyance void, albeit that doing it was a breach of planning law. So what's the consequence? Is it that the purchaser doesn't have good marketable title because nobody's going to take it off him if it was conveyed to him in breach of planning law, or what?
Well, my lord, it is interesting, and I think, if I'm reading my lord correctly, you have in mind the authorities where, irrespective of planning permission, a purchaser says, look, I know it requires planning permission, but I'll waive it and I'll take the property anyway.
I just wasn't thinking a waiver. I was just looking at a sort of vanilla question as to what the legal consequences would have been if your client had actually executed a conveyance of the property.
Well, assuming that it had happened in that way, the property that the purchaser now has would suffer from that difficulty, that it does not have planning permission for onward transmission. And in terms of obtaining his own certificate of title for the particular property, there may be difficulties.
I mean, I suppose the purchaser, if he's subsold, wouldn't actually be subdividing at all. He'd be selling all that he had, so that it wouldn't be a fresh breach of planning control. But presumably the planning authorities would have some power, if the original conveyance was a breach of planning control, to require it to be undone.
I haven't. I'll look at it as I say, but my understanding is that there are enforcement provisions, as one would expect.
But I think I'd like to be
yes,
insisted.
and the planning authority could then take enforcement action to prevent building on the property or dealing with the property.
Well, yeah, I'm concerned not so much. Yes, it's the dealing. It's the fact that it has been an unlawful subdivision.
We may find that there is also power to give permission retrospectively.
Yes, yes. And in fact, we accept. Well, part of the argument is that you can make an application, you can make the application after the event, and you can say, well, look, whatever for example, we didn't comply with certain things before, but we now can and have, then you can make the application and invite the authority to backdate it, so to speak. But let me go to planning permission, which is the second.
You've been shipping quite a lot of fire, Mr. Mayor.
Yes.
Just before you go to that, is it too simplistic to say that the statement that the above land has a good marketable title to the said premises can be other than a representation by the vendor that there is a marketable title?
Well, my lord, sorry, I may not be understanding the question.
Well, this is recorded at page 21. The above land has a good marketable title to the said premises, free from all encumbrances and so on. Can that be characterised as other than representation by the vendor that he has a good marketable title to convey.
No, and we say on behalf of the appellant, certainly the first appellant, that he had good marketable title to convey.
It depends what you mean by good marketable.
Well, precisely, and how that is defined, and this is what I was going to come to, in terms of whether that impacts on title,
must let you
conveyance, etc.
get on to your argument.
I'm very grateful.
Give you
My Lord,
a little piece.
Planning permission, or outline planning permission, the respondent says that they adopt a position in this appeal that planning permission was in fact granted, and or they argue that there is conditional consent. I'll give the board the references. It's page 410, paragraph 8A. I'm not inviting the board to turn it up because there's one that will probably deal with all of them. Page 410, paragraph 8A, page 411, paragraph 10, 415, paragraph 20, 22, and also 416, paragraph 23. But it's paragraph 19 on page 414 that I would invite the board to look at. Where one of the arguments the board will have to address is whether the refusal is, as they submit, in effect a conditional consent. We say that planning permission has never been granted for the subject matter of the contract, that is the excision and subdivision of the 8 lots. And if you look at page 72 of the record, that is the document headed refusal, notice of refusal of permission, and that is in relation to the 4 lots we have on the plan.
That's to develop.
Yes, and
by subdivision.
yes,
yes, thank you.
It specifically deals with that. We don't dispute, and there's no dispute between the parties that relates to the excision of the subject matter of the contract.
Yeah.
The 4 lots to the end.
The form of development.
And it expressly states you're refused permission to develop subdivision of land for residential purposes, as my Lord has seen.
This was the application of the
This is the application of the respondent on the 1st of March 2010. And it confirms the reason for refusal because it does not conform to the following site development standards, which are required to be maintained under present planning policy, including 1 recreational open space and community use site. The next document... Sorry.
Looking at that, subdivision of land for residential purposes was the development. I'm wondering whether simple conveyance by itself is subdivision within the meaning of the Planning Act. It seems to me subdivision implies you're doing something, actually dividing up the plots physically, and that mere change of title is not what the Planning Act is getting at, is it?
Well,
is there any authority on that?
Again, not that we have found from Trinidad and Tobago, but the way in which we understood the section to apply is that where you are seeking to change the use of the land, because this was agricultural land, as my Lord may already have noticed, and where you're seeking to subdivide from a larger parcel, that is...
Yes, you're lotting it out for development, but the authority is not worried about who has the title.
No.
What they're worried about is you're dividing up for residential use
the
without
use.
Providing the necessary open space. Which,
yes. But that is why, this was the point it goes to, this is why planning permission was refused. But in terms of dealing with the point that planning permission was somehow granted, could you turn to page 127? And the respondent relies on this, as do we, but for different reasons, to say that in fact this is not does not refer to the subject matter of the contract, because if you look at what is referred to in the opening paragraph, it refers specifically to 11 lots for residential use and 1 lot to be used as public open space. So what appears to have happened is that the respondent has made a different application for more land than was the subject matter of the contract.
What's the date of this?
This is, it's at the very bottom, the application states it was submitted on the 18th of May 2011. That's the end of the first paragraph. And the decision is the 20th of July 2011, bottom of the page.
But I mean, it's still the same area of land, isn't it? Or
It's the same parcel of land, the larger parcel, but what the respondent appears to have done is then gone beyond the subject matter of the contract to obtain planning permission and represent that therefore they did obtain planning permission, certainly for the purposes of damages assessment later. We say that is wrong because if you look at the bottom of the notice, in particular note number 1, the application is approved subject to strict adherence to every arrangement and detail appearing therein. Should any alteration be required, a new application must be made, leaving out a few words. So in short, if the respondent wished to only excise and develop the 8 lots, subject matter of the contract, he did not have planning permission.
I'm sorry, it's still the same area of 0.8169 hectares.
That's the whole parcel, referring to the whole parcel. Because they were trying to extract part of that.
So this was not a subdivision as required by the agreement?
Yeah, precisely. That's the short point.
It's not development, I mean, it simply isn't a grant for development by subdivision.
No.
It's just a grant for development.
It's a grant for development, but doesn't relate to the subject matter of the contract. My lady has the point, and that's all it goes to. So insofar as the respondent says that they did obtain planning permission, certainly as it related to the assessment of damages later, we say that that is simply not so. Now, the respondents, in relying on this, say that the trial was over by the time they received this and was adjourned at the conclusion before they were able to use this particular evidence, for example, to obtain specific performance. But if the board looks at page 249 of the record, we say that we can demonstrate that that is wrong. Because when the trial concluded in April, it's page 249, lines 7 to 9, the court said it could give further directions for submissions or for further evidence such as may be necessary. And of course, judgment itself was not delivered until the 31st of October 2011. So if this was a usable planning permission, there was nothing to prevent the respondent from saying, look, I've got this now, can I have specific performance? Which, if he had it, then the first appellant would be quite content for him to have the subject matter of the land.
Yes.
But I mean, does any of that affect anything we have to decide? As I understand it, the judgment which was eventually given was for damages, not specific performance.
Well,
there's no question of specific performance now.
No.
One thing that does puzzle me was that I think the judge directed, didn't she, that the larger plot was held on trust.
Yes.
To give effect to your interest in the relevant part, to their interest in the relevant part of it. Is that still the position?
That is still the position.
How does that lie side by side with the respondents having obtained substantial damages?
Well,
I mean, quantum isn't, I think, before the board, is it?
Well, it is, as the last argument we make in our case and upon which we sought leave, because as all of the discussions we're having in relation to planning permission, we will be asking the board to look at the issue of damages on the basis the court made it. We say that you couldn't order the damages at a value with planning permission when in fact the property doesn't have.
No, but the point hasn't been taken that they're the beneficial owners of their plot anyway under a trust of a larger piece of land.
We've not addressed the board in relation to that.
So it's just a curiosity which
Well, in actual
observe
fact,
and pass by.
Sorry,
It's just a curiosity which we observe and pass by.
quite. In actual fact, it is something that was subject to the direction by the trial judge and upheld by the Court of Appeal, that if by a certain date it was not effectively transferred back to the first appellant, the registrar of the Supreme Court had the power to do it. I don't know whether that has in fact happened, but certainly that was the order made. So even if the parties did nothing, the court would have effected that order. So,
Well, where are we now?
just dealing very briefly with this case of Richard West, page 654, and it's really page 656. B. Again, very small point. It's a misunderstanding we say, by the respondent of what is a conditional consent. A conditional consent cannot be a refusal, and that somehow you can work around the refusal. And the way in which Lord Justice Harman dealt with it, B, the consent therefore is not unconditional or an absolute consent. One of the points taken by the purchaser, the first point really in the case, is whether within the true meaning that is conditional on planning consent being granted, the condition has been satisfied. I'm far from saying that in some circumstances so-called conditional consent might not amount in effect to a refusal, but in this case the only condition of consent was about a sign, and all that involved was the purchaser should provide an adequate visibility display, etc. So insofar as it may be relevant, we say that that is not a case that supports that planning permission was ever granted. My Lord Care asked me, we move specifically to the remedy, why specific performance couldn't be ordered, and I've already addressed, but if I can just give my lords the reference, it's the trial judge's judgment, page 175, 176. We've already looked at it in relation to what she found in law and then found as a fact. But if you look, please, at page 176 of the record, having made what we say is a finding in law, which is at the very top of the page, she then uses that to bolster her finding of fact, that there was an agreement in the way she describes, with the first defendant having the burden of obtaining the approval. In short, she used the finding in law to justify her finding of fact. At the bottom of the page, she focused on the inability of the first appellant to transfer the land, my Lord Briggs's point in relation to title, but the way in which she dealt with it was effectively to say that the essential breach of the implied term is what renders the first appellant unable to transfer the 8 lots of land to the respondent, insofar as it is an implied term. That's the way in which she proceeded. And the transfer of the land to the third appellant was an additional consideration, but not the breach, according to the way in which she's phrased it, which was an additional factor that could be overcome. The critical problem was the absence of planning permission. And we say it's again illustrated where, in recognising the contract could not be specifically performed, she based it on an implied term, and this is page 180 of the record, a different part of the judgment in the middle of the page. However, it would seem to me that while the agreement is unable to be specifically performed, this is as a result of the failure of the first offender to do what he was supposed to do, that is, obtain the relevant approvals for the subdivision of the larger parcel of land. So in these circumstances, we say, and I it's one of the questions the board has put to me, that the transfer of land to the third appellant was not the breach of contract, certainly not the operative one. It was the absence of obtaining planning permission. Turning to page 341, it's line 38. This is the Court of Appeals extempore judgment.
Just stepping
Sorry.
aside from the judge's analysis for the moment, do you maintain here that it wasn't a breach of contract for your clients to one of your clients to transfer the land, the vendor to transfer the land, after having received payment of the purchase price?
You say it was not the operative breach of contract in light of the judgment, but I know my Lord phrased the question, putting aside the
Yeah, leave aside questions of causation and so forth and loss, but do you say it wasn't a breach?
Well, we say it's not the operative breach. It's not the reason why we've come this far, so to speak. But if I can deal with it neutrally in this way, if you make an agreement with someone and you then break that agreement by transferring the property you agreed to sell them to someone else, that would almost certainly be a breach.
Almost certainly.
I don't think I'm giving anything away when I say that.
But Mr. Beharala, if it was a breach, let's just think about purely hypothetically for a moment, and it wasn't the operative breach. One would ordinarily think that transferring the land out of one's own ability to convey it was pretty good as a breach. And it's the only reason why it's not the operative breach, because there's some much more serious breach.
Well, my Lord, again, had the court decided it on that basis, then matters may have proceeded differently, and I may not have had the pleasure to come before the board today. But, what we say, my Lord, is that, and I make it squarely on the case we've made, that because the implied term was the mischief, and the breach of that was the breach that the Court of Appeal said is to be held against the appellants, we say that that is the operative breach, that is the focus of the appeal, and if the board agrees that there was no such implied term in law, then that should favour a disposal in favour of the appellant. My Lord, 341, which is the Court of Appeal's judgment, same point. And again, I'm trying very hard to answer the question, is it really about an implied term? It's page 341, lines 38 to 43, where the Court of Appeal says this: the core appeal is whether her findings in relation to the terms of the agreement are material. Certainly, if the findings as to the terms of the agreement are wrong, then that would impact on the findings in the order of the judge in relation to the other matters. I'll deal with these at the end, keep them. I may have some answers to some of my Lord's questions in a moment. And then 344, lines 3 to 19. We agree, 3 to 19. We agree with the judge that it is a term that in any event would be implied by law. And we think that the way the judge dealt with it is correct, in that it is the obligation of the vendor to show or to pass good and marketable title. And if the law provides that land is not to be subdivided unless permission to subdivide is first obtained, then it seems to us that that goes to good marketable title. And in the absence of any contrary agreement, that must be on the vendor to obtain that permission as part of his obligation to pass a good and marketable title. So the judge's ultimate conclusion that there was a breach of the agreement by the vendor first appellant, and this is the important point, and that the agreement was unenforceable, seemed to us to be well-founded, and that's the basis upon which she made the orders that she did. So even the Court of Appeal, we say, took the view that the breach was the first appellant's failure to obtain planning permission, as distinct from the transfer of the land, which was implied in law, rendering the agreement unenforceable.
You don't, I think, do you challenge the judge's conclusion that in the light of the absence of a planning permission for subdivision, it would not have been appropriate for her to order specific performance?
My Lord,
I'm sorry, I shouldn't put it in that slightly. Do you or don't you?
well, my Lord, I am aware that, no, because the respondent did not waive the requirement of planning permission. It would be a different matter if he'd said, look, I'll take it without. And there have been authorities that have, of some age now, that have come before the board that if the respondent were to say, all right, fine, I waive the requirement of planning permission, then they can take it without and get specific performance on that basis. But here, the respondent did not waive planning permission, so specific performance would not have been appropriate. I hope that answers my Lord's question.
Yes, you have, thank you.
My Lord, final part, should the courts below have implied the term in law? Well, we've addressed that. We say no. We also say that from the Court of Appeal's recent reasons, page 9, paragraph 26, which we've looked at, but could I invite my Lords to look at it, because I know that now the Board is likely to have regard to that.
Paragraph?
Paragraph 26, page 9, paragraph 26 of the fresh reasons.
Oh, the fresh reason.
And it's, we say relevant. In our brief researches, we have been unable to find any direct authority for the proposition that an agreement for sale contains an implied term that the vendor is required to obtain planning permission for the excision of lots to be sold from a larger parcel of land. This concession by the Court of Appeal is also clear from page 12 of the judgment, paragraph 32, where the position now is that accordingly, without intending to lay down a general principle applicable to all contracts for the sale of land, we hold that in the circumstances of this case, the trial judge was correct to hold there was an implied term that the vendor would bear the responsibility of obtaining planning permission to subdivide the larger parcel. For what it's worth, the Court of Appeal seems to concede, at least in this regard, that it was an error of law, as we say, to impose on the vendor a duty to obtain planning permission as well as law.
In the last sentence, the court appears to be saying that without planning permission, there could not be a transfer of title at all.
Yes, and that really is we disagree, and we say that there is guidance that supports our position in saying that it doesn't go to title, it does go to conveyance. So, to use the phraseology, it's not a matter of title, but it is a matter in relation to conveyance.
Sorry, I don't understand the distinction.
I know, and I wanted to deal with that as one topic. I mean, I am going
Right,
to, my Lord.
very well, thank you.
My Lords, I've said there's no dispute, but it may be worthwhile the Board taking reference to this. We've quoted Chitty on contracts. We don't take the Board to any of the authorities because they've been digested very well in Chitty, and the summary is accurate. It's page 741 of the authorities bundle and 742.
Yes.
And insofar as the relevant part, there's a summary of the Board's decision of Ali versus Petroleum Company of Trinidad and Tobago at 14-013. And then in terms of terms implied in law, 14-015 and over the page, 14-016. 14-016, 3 lines down. The implication of a term into a contract assumes that there is a concluded contract into which terms can be implied, and it is not legitimate for the court, under the guise of implying a term, to make the contract for the parties. My Lord, can I take you, please, and probably do this quite quickly, page 204 of the record. And it's lines 38 to 43, where in the course of the evidence, the respondent whose evidence is preferred indicates that he was aware from previous conveyancing experience that it was the purchaser's obligation to prepare the agreement for sale. And we say that that's highly significant where it was the respondent who prepared the memorandum and did not include any term concerning planning permission. And And if I can give the board these references rather than take you to it. Record page 200.
Does he actually mean the agreement for sale or the conveyance?
Means the,
Because unless there's a contract, it's a little difficult to understand anybody be under an obligation.
it's the drawing up of the agreement.
What, the contract?
And in fact...
And is that an obligation arising out of an earlier purely oral contract?
No. This is where we say industry practice is one of the considerations in relation to whether you imply the term at all. And
I see.
if I can deal with it now, the board should have this document. It's a new document, and it may be helpful to look at it, because one of the things that we attempted to do was to try and identify, as far as we could, any standard practice terms for Trinidad and Tobago. This is the closest we come to it. It's the way in which conveyancing lawyers are trained. Sorry, it's the extract, Council of Legal Education at the very top.
Ah, thank you.
Maybe towards the back.
I've got it. Thank you very much.
Bundle.
You say it somewhere in the papers.
Yes, it was handed up. It was the back of the bundle that the board had at the very beginning. It may be at the back of that, potentially.
Oh, yeah.
Absent a set of standard terms and conditions as has been issued by the Law Society in England, if the board turns to page 15, it's a useful document in that, insofar as there is learning on the local conveyancing practice. If you look at page 15, this is the way in which lawyers are trained to deal with it. And if you're acting for a buyer, the flowchart sets out the obligations on the part of the buyer, purchaser. Specifically, pre-contract searches and inquiries, approve draft contract, investigate title, prepare purchase deed.
Yes, well, that accords with what I would have expected. It's not the preparation of the contract, but the conveyance, which is the purchaser's ordinary expected task.
Yes, I may not have quite understood, my lord, but if I can invite you to turn to the next page, which is the nub of the thing, planning permission. The very next page, middle of the page, the pre-contract stage, in terms of the preliminary inquiries and searches on the part of the purchaser. One of those is to ascertain what the statutory restrictions on the use and enjoyment of the property are. Towards the bottom of page 16, reference to the rule of caveat emptor, and then turning over the page, middle of the page, planning approvals. These are not matters of title enabling the purchaser to rescind the contract. So the way in which it appears to be approached in Trinidad and Tobago is that planning does not go to title, which was one of the critical questions that the board asked me earlier.
We can hardly take as authority a
No.
Council of Legal Education guide, and certainly in this country, planning approval would not be regarded as a matter of title. But in Trinidad, we have the problem of what is meant by subdivision as a concept.
Well,
I mean, the Court of Appeal seemed to have decided in agreement with the trial judge that it did go to title.
yes, and this is where, if the implied term in law is made, this was a relevant consideration. And that's the relevance of it in terms of local industry practice.
But I mean, you can't call this local industry practice. I mean, it's...
Well, you're right, my lord. Perhaps not local industry practice, but if this is the way in which conveyancing attorneys are trained, then it is a relevant consideration in the context of this case, where we say that the onus should not have been placed on the vendor rather than the purchaser.
As a perfectly general statement, it's no doubt absolutely true that a prudent purchaser solicitor will make planning inquiries is before recommending to his client that he contracts to buy the property to make sure on completion it can be used for his desired use. But in the particular circumstances of a sale of development land by subdivision, where there is an unusual statutory prohibition on subdivision, as you found, on actually conveyance, it's odd to treat a very simple and general and helpful guide like this as necessarily applying in that situation.
My Lord, I agree, but the reason I've referred the board to it is that in terms of trying to find guidance that may emanate from Trinidad and Tobago, this is as close as I was able to get to it. If they had issued the standard terms and conditions for sale that we have an equivalent of in England, as I say, we may not all be here now. My Lord, in relation to the questions, if this were a implied term in fact, as the Court of Appeal now reasons, if the question were asked, well, who would apply for planning permission? A relevant consideration would be, is the land being sold at a value with or without planning permission? In this case, I don't think there's any dispute. The land was being sold at a value without planning permission, $500,000, but with planning permission, it's worth in excess of $2 million. And as a relevant consideration as to who would bear the burden of obtaining planning permission, we would say that it would not naturally be the vendor if the vendor is selling without that value. It would be a different matter entirely if he was saying, well, look, I'm selling this property with planning permission, and therefore I'm entitled to more.
Are there two different sorts of planning permission, though? One, to subdivide the land so that it can be sold, and secondly, planning permission to erect buildings of a particular kind and nature on the plots?
The way in which, yes, the way in which well, I suppose it depends how the application is phrased for planning permission. The application here was phrased for subdivision and then creation of lots for residential building.
That was the application?
That's the application that is
by the respondent?
By the respondent.
But you're saying that the value was as agricultural land?
Yes.
And, I mean, was there a finding to that effect?
There was no finding in relation to agricultural land. The way in which the trial judge dealt with it is that she would, in fact, it might be worthwhile just taking my lords to it. It's the judgment at page 180, which is the judge's judgment, bottom of the page, or towards the bottom of the page. The way in which she deals with it is like this. In all the circumstances of the case, it seems to me that this is an appropriate case for an award of damages.
Sorry, I'm not...
Oh, sorry. It's page 180 of the record.
Yes.
Bottom of the page.
At all material times, a second defendant.
No, sorry, the paragraph before. Third line, in all the circumstances. This is an appropriate case for award of damages in lieu of specific performance. In the circumstances, the claimant is, in my opinion, entitled to damages representing his loss of bargain as of today's date. These damages will be assessed at a later date, and then decides not to give aggravated or exemplary damages because the claimant would be adequately compensated for any rise in the value of the land.
By any rise in the value of the land,
By
she
any
says,
rise in
which makes me think she's assuming that the purchaser's going to get his value by being a beneficiary under the trust which she says exists.
Well, the way in which I understood that, my lord, is that because of the gap in time between when the contract was executed, the natural increase of value of land, that is what she had in mind. She didn't specifically say, I'm going to give you compensation or damages at the level of the value with planning permission, because this land has no planning permission.
That all lay in the future on this day.
Sorry?
All going to be assessed.
Yes, it was to be assessed at a later date, and then it was assessed in reliance on Mr. Gooman Singh, who gives Yes, it's notice it's page 251, and in answer to my Lord Carnworth's question about agricultural land and findings, if you turn to page 253, there are the photographs which the judge would have had regard to as to the status of the land, and it would have been obvious looking at it, we say that this is agricultural land because these are photographs taken from the road looking into it.
Right, well, let's move on.
Yes. My Lord, we've mentioned the pleadings point in the case. I'm not going to address the board on that unless the court wishes me to. In terms of posing the questions, without planning permission, we say that in this particular instance, if the question were asked by the officious bystander, who would apply for planning permission, once they knew that it was being sold without planning permission, they would naturally say the purchaser. My Lord, in terms of the damages aspect, coming to the end of this submission now, could I invite you to look, please, at page 34.
Yes?
And it's paragraph 5D. This is the respondent's defence to counterclaim. And we do rely on this, but what we say is that even the respondent accepted that it was not within his power to obtain planning permission. And we say that that cuts both ways. It's not possible for either party to obtain as distinct from apply. And we do say that since the onus as to inquiring about or applying for planning permission is on the purchaser, unless there's an express term, you would not imply that as against the vendor.
So I don't follow paragraph D. The basis for forfeiture is the inability
Yes.
to obtain permission, which is impossible for the claimant to comply with since such approval is not within his contract.
Use the words contract, his ability, rather than town and country. And what he's dealing with there, my lord, is the assertion at the trial that the appellant was entitled to forfeit a percentage of the purchase price, and in dealing with that, he prays in aid the inability to obtain town and country approval, effectively because it's within the gift of a third party.
But this was a pleading which responded to an allegation that there was an express term
Yes.
putting the burden on the respondent,
Yes.
which the judge has rejected on the facts.
Yes, absolutely. But the way in which we seek to rely on it is that it can't be disputed that neither vendor or purchaser could obtain planning permission. They couldn't be held to that where it wasn't within their gift to do so. And so insofar as the implied term in law may be operative, that was a consideration to say, no, you can't imply a term as against the vendor. My lord, turning please to two particular cases, 377, which goes to the issue of conditional contract. Sorry, 377. I think we've looked at this already. This is the part of the extempore judgment which says that the contract was unenforceable. We put it differently and say that where there is no express term for planning permission and absent an implied term, as we say there should not be, there was no binding contract. We rely on that, in support of that, on page 448, which is the case of British Bank and Novinex. Oh, Lord, I may have given you a wrong reference.
No, that is British Bank. And
Yes, sorry, it's, no, it's the wrong reference.
Lord Justice Cohen was judgment.
Sorry?
Lord Justice Cohen's judgment.
Yes.
Is that what you want to refer to?
442, sorry.
442.
It's 442 in the authorities bundle. I knew I'd...
Oh, this is Bury and Royal Bank of Scotland.
And it's... the very next page, in fact, bottom of the page of the head note, beginning with the words, "The court approved." There's a statement of Lord Denning.
Can you give me the page?
Sorry, it's page 443, milady.
Yes.
And it's the authorities bundle, and it's the last paragraph, the beginning of the last paragraph.
The court approved the
Yes.
statement of the
Yes.
trial judge.
Yes. As to the law applicable to the first point, principle to be deduced from the cases is that if there is an essential term which has yet to be agreed, and there is no express or implied provision for its solution, the resultant point of law is that there is no binding contract.
But it's not conditional contract, it's no contract at all.
No contract at all. And in this particular instance here, there's no express term, but even if there had been, the best that would occur is a conditional contract which would either be a condition precedent to contract or a condition precedent to performance. And if the board turns to page 750 of the authorities bundle,
$450.
750.
750.
I'm so
yes,
sorry.
You're quite right, my lord. 750.
Yep.
And this is the learning in Barnsley, which, as I've indicated, is a practitioner book which is relied on by practitioners in Trinidad. Condition precedent to contract. The condition may operate as a condition precedent to the formation of the contract for sale between the parties. A condition of this type has the same effect as subject to contract qualification. No binding agreement exists unless and until it is fulfilled. Either party is free to withdraw without awaiting its fulfilment or non-fulfilment. And then they refer to the Privy Council case of Aberfoyle, which was expressed to be conditional upon the vendors obtaining a renewal of certain leases, and the board in that case took the view that until the condition was satisfied, no contract for sale could come into existence.
But that was a case where there was an express condition precedent.
Yes, and this is one of the reasons why we say that this is not a case for implied terms at all, because in all of the reported cases, or certainly most of them, the agreements reflect the position of the purchaser. And if you turn to the very next paragraph in Barnsley, the condition precedent to performance, which we say is the alternative argument, and it seems the one more frequently agreed upon, the condition is held not to prevent the formation of a binding contract. Its non-fulfilment renders the contract unenforceable by either party unless the condition, being for the sole benefit of one of the parties, is waived by that party. And so in this instance, whilst our primary submission is that the contract is silent and it was not for the courts to imply a term, even if it had existed, the best that would occur would be a conditional contract.
But you're not advancing that as a separate and self-standing argument. What I'm trying to ascertain is whether or not it's part of your case that because both parties knew that planning permission had to be obtained and either could obtain it, that in some way there was either a condition precedent to performance or to there being an agreement at all.
Well, the first submission, my lord, is that there's no agreement at all. The way we've put it in our case is that once we establish that there's no express term which cannot be implied, then that's an essential term missing. And so the agreement does not come into effect. And this is why I wanted to deal with it last, because as the question was asked by my Lord Briggs as to whether the transfer of land could be a breach in itself, if there's no contract for the reasons we've just been discussing, then there would be no breach. And that's why we say that it is an important term,
Yes, if there's no contract, I can quite see you can transfer to whoever you like.
Well, quite. And that's the short point. That's why we say that this is relevant, because if it is a condition precedent to the formation of the contract, the appellant's not in breach. But if it is a condition precedent to performance, it's one that could not be fulfilled, and so the contract is, we say, unenforceable. My Lord, this is why we say, and it's the last submission, the board will be happy to know, why on the pleadings and the case being tried by the judge, the respondent was entitled to a return of his monies, and the appellant concedes that that is the proper course where the contract could not be performed and we say was unenforceable. Finally, could I invite you to look at 26 on that point, page 26, sorry, of the record. And it's a small point, but perhaps a relevant one on the issue of damages. Because if you look at paragraph 16 and 17, although it's unusual to see it in a pleading, the case for the appellant, which wasn't really dependent on any findings by the judge, but as an acknowledged fact, is that the claimant spoke to the first defendant stating he would like to settle the matter by returning the claimant the agreed sum of $250,000. The claimant insisted he wanted $500,000 in addition to $70,000, which he paid as fees to Town and Country approvals. Paragraph 17, the claimant was content with the first defendant's acceptance of his request, but the claimant later decided against that agreement and stated instead he wants the land. So even at the pleading stage of this case, there was no issue in repaying the respondent both the purchase price and the $70,000 he said he...
Well, you said there's no issue, but your client was not in a position to repay.
There was certainly, well, that was the respondent's evidence, but having pleaded the case in that way, certainly as it is favourable to the respondent and adverse to the appellant, we rely on that still. And this is why when we sought leave from the board and in our written case, we accepted that he was entitled to have his money back.
Yeah.
My Lord, can I assist the board further on any other issue? I've tried to answer all of the questions.
You have done valiantly well. Thank you very much indeed.
My Lord, can I... I've got... What is it? Okay. Mr. Paryag Singh, who's following the proceedings online, has messaged us in relation to, I think it was my Lord Briggs who asked the question, the third appellant holds the property on trust for the respondent still, and the respondent is the beneficial owner.
And there hasn't been any subdivision of the title.
No.
Is the trust of the whole property or just of the potentially subdividable part?
Well, the difficulty is the way the order was framed, I think, related to the whole. But I'll double check that, because there was some discussion in the Court of Appeal towards the end as to whether the order had been correctly framed by the trial judge.
I mean, if the problem was that the land couldn't be subdivided, it might be that the judge intended the trust to apply to the whole property, so that by a sale of the whole, for which there was presumably perfectly good title, the respondent could receive its proper payout by reference to its beneficial interest in part.
I will double check that, but as I say, I think there was a variation of the order in the Court of Appeal, but I'll make sure. But my Lord, I've also been told that there's another case, again, Mr. Paryag Singh informs me, in relation to implied terms from Trinidad, and I think we have it here. I'm going to double check that we do, because it may answer one of the questions that was put to me as to whether this has arisen. I think it was my Lord Carnworth asked me if it had arisen before.
Well, I was concerned about the issue of planning the effect of subdivision, not about implied terms more generally.
It may go to that, so I'll double check.
The planning permission was granted in July 2011. Is that still extant? Do we know? I mean,
I think it would have lapsed by now because it's for a fixed period of time. Again, I don't know the
do we know
answer
if
to
it's
that.
been renewed? I mean,
No.
presumably nothing's happening on
I don't think
this.
it has been renewed, the 2011 planning permission. Sorry, the subsequent July planning permission. No, it's not been renewed.
Thank you very much, Mr. Bahari. Mr. Hitchens?
Yeah, thanks, Lord.
Yeah. We'll retire for a few moments. Mr. Lever, my Lord Briggs has a question, and my Lord Kitchen has a question, and we'll proceed in that manner. First of all, Lord Briggs.
Mr. Lever, I have an enduring puzzlement about the status of this trust of the larger plot of land. It appears to be confirmed very specifically on instructions through Mr. Bahari, that the trust continues in existence. It's a trust of the whole property that was transferred between the appellants. But you've got, as I see the judge's order, you've got damages for the loss of this purchase contract and on the basis of loss of bargain. Are you entitled to those damages and to a realization of your interest under the trust, or is the interest under the trust just some kind of security to make sure you get your damages?
Indeed, Maloo. Before I comment, Maloo, this is my very first appearance.
Yeah,
Well,
welcome here.
Yes.
and I have my colleagues, Mr. Ramnath
Well, they're very welcome as well.
and Mr. Hanuman, who has volunteered to help us.
Good.
My Lord, it's a nice question. Surely the respondent will not be entitled to both the damages and, of course, the land.
Yes.
It will be unconscionable. I think why it was done this way in Trinidad is that no portion of a larger piece of land that fall under the Real Property Act, could be transferred or conveyed out of that without an approved plan, without approved planning. So the planning process must be gone through outline approval, then the substantive approval, and then you get an approved plan. That plan is used now to be annexed to a memorandum of transfer to transfer that plot. So in this case, if all had gone well, there would have been 8 memoranda of transfer.
Right. But perhaps you could direct your reply to the specific question that my Lord has posed. What about the trust?
Right, so that's what I'm saying. So if, as it is, we don't have the approval, the portions of the 8 portions are still with the parent parcel.
Yes.
And that the trust is with the parent parcel in so far as the money is concerned. Because the court did hold at the trial that the transfer of the entire lands to the sister was put by them that she bought 4 plots only, lot 1, 2, 3, and 12. So their case was the sister bought 4 plots, but the entirety of the land was transferred to her. And that the remaining land would be Somar's, the respondent. So in reality, the owner of the land, the first appellant, would have no interest in the land anymore. So this is the reason for her, the sister, holding it in trust so that
Or the
the respondent gets damages.
I see.
So it's to make sure the respondent gets their damages.
Get it done.
Thank you.
My Lord Kitchen has a question.
Thank you. Could I please ask you to look with me at paragraph 32 of the Court of Appeal's recent judgment?
Leave me alone.
And you'll see that in the last sentence of that paragraph, the Court of Appeal say that without it, that is to say, without the permission, the vendor would not have been able to fulfil his obligation to provide a good marketable title. Well, that's, I understand, so thus far. But they continue, or to effect a transfer of the 8 lots to the purchaser. Now, a moment ago in your submission in response to the question from Lord Briggs, my Lord Briggs, you, I thought, adverted to this very point, that unless you have permission, you can't effect a transfer at all. Is that correct? Or
That is so, my Lord. And what I said earlier about the 8 memoranda of transfer would be applied to this case.
And what is the basis for that submission, that you simply cannot effect a transfer at all?
At all.
Without permission?
Without an approved plan annexed and filed with the transfer.
Is that provided by statute law, or
It is.
has that been explained in some case, or what?
It is under the RPA Act, the Real Property Act.
Which provision of the Real Property Act?
My Lord, I did not know if it will come up, but if I may explain. Lands that fall under the Real Property Act are evidenced by certificate of title. The mirror principle. The principle is called the mirror principle, where everything is reflected, all the ownership, mortgages, caveats, and so on, are reflected on that title.
Which provision are you referring to?
Pardon me, my Lord?
Which provision?
I did not know it would come up, but Mr. Rahman can my Lord, so no land at all, without a plan, can be transferred, because no certificate of title could be issued without a plan on the record. So I am hoping to get this section
I
shortly.
think this is a form of land registration, I think
Land
you're
registration.
describing, and you wouldn't get the land registered or a certificate of title from the registry unless you transferred it properly with an appropriate plan.
Indeed.
But would the registry refuse a certificate if it had been transferred without planning permission for subdivision?
They will, my Lord.
Right.
But an example,
They will or will not?
they will not register it without an approved plan. There is an example of the certificate of title attached to the pleadings, in which it is mentioned that the plan is filed at volume X or Y or so, and boundary and so on. So the plan is always mentioned in RPLN. I can refer to the certificate of title. It is at page 56 of the electronic one.
Page
It's
56.
really 56.
Yes, thank you.
And this really is the certificate of title for the parent piece of land, the entire parcel of land. But I'm using it by way of an example to show that this will say that, if I may read, my Lord, starting from about the middle, comprising 2 acres and 3 purchases, be the same more or less, delineated and colored pink in the plan registered in volume 1640, folio 403, being portion of the land described in the Crown Grant and so on, my Lord. So every certificate of title, there is mentioned on the certificate where the plan is filed, and that plan is required to be attached to the memorandum so that this could be issued and referred to it. So to take it a bit further, it was not possible for the purchaser to waive the planning approval and still get a transfer. That was not possible.
Yes. Anything else you want to say, Mr. Nival?
Well, I take it I've done written submission, and I'll be
Yeah.
willing to assist the court if I have nothing further to add.
Headline point.
You want to?
It'd be useful just to have his headline.
Headline points.
It would be very helpful if you could just give us the headline points, the roadmap for your submissions in just a few minutes.
Maybe I should commence just 1 minute for that.
I mean, we have your written
but
case, Mr.
I would like to
Nival.
refer to,
So,
I have briefly summarized
Yes.
what happened prior to the making of the agreement. There was, at paragraph 21, this is evidence coming out of cross-examination, where the first appellant, being the owner, said he informed the respondent that I did make an application for planning approval. It is pending. They, meaning the planning department, have indicated that they cannot approve it in that way, that manner, and that they were asking for, in his words, 10% of his land to be allocated for public space. And then he, in that same cross-examination, he said he mentioned this to the respondent purchaser, but didn't tell him
yes.
that I will not agree to those conditions. In my submission, I have alluded to that because this is what, if I may say, starts the conversation which ends up in the agreement, leading the purchaser to believe that the condition will be fulfilled and I will get my land. Because both parties knew that the planning approval at that date was not in existence. But this conversation where he volunteered that it is pending, and the reason why it was pending is sort of lead the purchaser to make the agreement, make the full payment. But what became more interesting later, my lord, is that the entirety of the vendor's case was that there was an express term in a written agreement, their version of the agreement, that imposes a duty on the purchaser to obtain planning permission within a year, failing which half of his deposit will be forfeited. And we know the result of that contract. Why I'm making this point is now that it is unfair, if I may use a mild word, it is unfair, but paradoxical, that the vendor can now say, well, I have tried to bring it by foul means, by an express term, through fraud. But I would ask this Honorable House to now imply that it was the purchaser's responsibility to get it.
Yes, we have that from your written submissions. It's very clearly put. But it would just be helpful to have the outline points that you were going to make, not to fill it all in at this stage, so we can see where we are.
So our case was commenced on the basis that there was a breach of contract at the time the entire parcel of land was transferred. That immediately upon that breach, which was admitted, any court would normally order damages. The question really to go forward is to assess the damages, and by what means should the damages be assessed. And throughout our submission, we have indicated that the purchaser would be entitled to the loss of his bargain. And his bargain would be what would be the value of the land in the vendor's hand, but in this case, in his sister's hand. What would be the value? I know earlier my friend did indicate that it was agricultural land and that with planning permission it will have fetched a higher value. I do not think that is the position. It was not mentioned in the court. What happened in the court below, and we can see from the evidence of the sister, she says, I bought 4 lots of land, lots 1, 2, 3, and 12, for $290,000, which is, boils down to about $70,000 a lot. And Somar bought sometime before that 8 lots for $500,000, which is more or less within the same range, price range.
Yes.
What I think may have happened is that the eventual increase in value is what was substantially the cause for the current assessment of damages and the valuation and so on. And that surely the same price the sister would have paid, assuming there was approval, because she bought them in lots 1, 2, 3, and 12. Assuming there was approval, as we indicated earlier, that you can no purchaser could get a transfer of land without final approval. So I'm thinking that the price range would have been the same with approval. What amounted for the high, I may say, damages awarded is the appreciation of land within a short period of time because of what was happening in the economy in Trinidad and Tobago at that time. So I cannot say surely that it was really the approval that brought about this high value. I won't say that. If I can assist in any way else.
Thank you very much indeed.
Thank you, Lord.
Mr. Bahari Lal.
Lord, in relation to the question you put as to the Real Property Act, I think I have found the section that the learned friend may have had in mind. I don't know whether the board has a copy of that act, but Section 33 of the Real Property Act, and I mention this, my lord, I should say, to assist the board on the law.
Yes.
Section 33, every original grant or certificate of title bound in the register book shall have drawn on or attached to it a map of the land therein comprised, which map shall be provided by or at the expense of the applicant. But this is perhaps the important part after a semicolon. And every certificate of title subsequently issued shall have either drawn on it or attached to it a map of land therein comprised, and provided in like manner, or shall refer to a map in which such land is delineated and which is already contained in the register book. It appears that the Real Property Act may have an interaction with other legislation, because Section 34, dealing with maps again, says every map, plan or diagram required for the purposes of the Act shall be prepared and furnished in the manner specially provided for the purpose by the Land Surveyors Act and by the rules made thereunder. And that may explain why there are features in the evidence as to why we had to have a formal survey. The diagram we were looking at, that is prepared by a surveyor, because there is some reference that this was actually, he was formally seen for the purposes of planning permission. I hope that that is helpful on the law. In relation to the valuation, I say my learned friend is incorrect, and I can demonstrate that. Could I invite you to look, please, at page 252 of the record? This is the relevant page of the valuation report, and what you will see in the middle of the page are the values attributed to each lot on the basis of the real estate market, etc. But if you look at the bottom, just after the total figure, total value, it says all assumptions and limitations in my previous detailed valuation report still apply. And the assumptions...
Sorry, which page are we on now?
Sorry, this is page 252 of the record.
Oh, I see this is the valuation report.
This is the valuation, and the point, as I understand, has just been addressed, is the valuation with or without planning permission. This is the valuation with, assuming planning permission, and we know that, if you bear with me,
Well, by this time it had got planning permission, as we know.
no, they didn't, and that's the point. They've never had planning permission for this property, but the valuation assumes planning permission. I found it. Could I invite the board to look at 139, This is the exhibit to the witness statement of the surveyor. And again, if you've got it, 139, middle of the page, that's the valuation, the market value. But if you then turn...
Hang on, 139.
139 of the
Yes.
record.
2035, yes.
Yes, and that gives the valuation for each lot and then the total.
Yes.
And then if you turn to page 144, you get the assumptions the surveyor made for the purposes of giving that valuation.
Yes.
And at assumption number 4 on page 144, he assumes all relevant approvals would be available for construction of a residential building on each lot. And this is why we say the valuation that has been, the value which has been attributed for the purposes of damages has assumed planning permission.
Yes.
When in
But
fact
assumed
there
it
is
would be granted for the construction, but it's on the basis that permission has already been granted for subdivision.
absolutely assuming planning permission.
No,
This is-
it's been granted by then.
No.
Oh, you assured it.
This is the point. The report assumes the value, the open market value with planning permission. But in actual fact, as I've shown you with the notices issued from Town and Country, planning permission has never been granted for subdivision and excision of the
I
lots.
don't understand that. We were shown a permission granted for subdivision, and that seems to be the basis on which the assessment of damages proceeded.
No, well, as I can show it. I can show it to my lord again. If you look at, I think it's.
I mean, that was the evidence given by Mr. Somar, page 152.
Well, by the time when evidence was
January
given,
2012, the subject lands have now been approved for development by the division.
Well, this morning you
That-
showed us a refusal for subdivision and a permission for development.
yes, but it's the permission I need you to look at again, because if you look at page 157, this is the grant of planning permission that Mr. Somar obtained. But if you look at the first paragraph, it does not relate to the excision and development of the 8 lots. What he has done, it seems using the same plan, is obtained a planning permission for 11 lots and 1 open space.
I mean, there's no findings about this.
No,
We can only proceed on the basis that the judge had before her the report, the evidence of Mr. Somar, that permission had been granted, and she gave damages on that basis. I don't understand what you're asking us to...
No. Well, my lord, we say it's very clear. The judge had the valuation from Mr. Roy Goomansingh,
Yes,
and the amount
and
of
awarded
damages,
damages on that basis.
and she awarded damages on that basis.
Can't go behind that.
No, I'm not going behind it. That is what she did. But she has assumed planning permission from this report. And my point is there isn't any. So the value of the land as of today's date will be a value without planning permission. So if the judge was assessing damages, she should not be assessing damages with a value with planning permission because the land doesn't have it.
You haven't got permission to appeal for that, have you?
Well, my lord, we mentioned it in our case, and we mentioned it specifically because I think we did have permission. If you look at the...
No, but I mean, if you're trying to raise a point that permission, which appears on its face to be perfectly valid, is not a permission, or is permission for something different, we would have had to have had some sort of notice of that. The other side would have had to.
I invite you to look at our case. It's really to answer the question, do we have permission on this? And we say we do. If you turn to it's page 11 of our case, but it's paragraph 43.
Which, the bundle page?
Sorry, bundle page 405.
Yeah.
It's paragraph 43. And the reason we say we did get permission on this, just looking at the grounds upon which we had leave,
But your paragraph 43 point is effectively saying, as I understand it, the contract went off and all the purchaser gets is his money back. It's a restoration of price rather than damages. It's not saying, but if he's entitled to damages, the judge got the assessment wrong.
Just looking at the grounds upon which
Yes.
we were granted leave, was,
That's 371.
well, it's ground 12, which we sought to address in that paragraph,
Get permission.
and it's the Court of Appeal erred in failing to have regard or sufficient regard to the fact that the only remedy to which the respondent was entitled was a full refund of his purchase monies, which the appellants concede is the proper remedy in this appeal. But that is predicated on the basis that the value of the land is not a value with planning permission, and we demonstrated that in reference to those documents. Certainly the judge proceeded on the basis of the permission.
Order granting permission to appeal is at 349. Permission to appeal in respect of grounds 1, small Roman numeral 1, 2, 1, 3, 4, 7 and 8, 9, and 12.
Yes.
But,
It's
but,
12 we sought to address.
but 12 is just saying the only remedy is a refund of the purchase money, not damages. So it's not taking issue with the quantum of the damages. It's just saying you shouldn't have had damages at all. You should just had your money back.
That is correct. No, I accept that, my lord. But in terms of the discussion we've had, in terms of identifying how the judge proceeded, she has proceeded to assume damages on the basis of planning permission having been granted. And the point is that's wrong. I don't know how far it takes me, but I draw it to my lips.
But if you've got permission for 11 lots and one lot to be used as public open space, doesn't that mean you've got permission for each and every lot? And maybe he only wanted 8 of them, and the sister would have got the benefit of the permission for the other 4, but it must be a separate permission to divide up the lots he wanted.
Well, my lord, it won't be. And the reason I say it won't be is when you look at the notice, which I took the board to earlier, it's restricted. You can develop the property in accordance with the permission granted, so 11 lots in that instance plus the open space. But you would not be permitted to undertake a different development, which was the subject matter of the contract, i.e. 8 lots and no open space. So if he had wanted to make that application, the notice itself makes clear that he'd have to make a fresh one.
But I mean, we have, as I said, page 152, the evidence of Mr. Somar in January 2012, that the subject lands have been approved for development, which I assume he means irrelevant development. Now, is there somewhere where you've taken the point that that's wrong?
Well, my lord,
Until today?
Well, prior to today, no.
No, well, I mean,
not.
this was the evidence before the judge
Yes.
when she comes to assess damages in May that year. I mean, how can we go behind that?
No, well, if you look at the amount of damages she's taken, she uses the report of Roy Gumansingh to fix those damages because it's the same amount.
Yes, but with evidence before her, unchallenged, that he's got planning permission.
No, but if he'd had planning, but my lord, if he'd had planning permission, he'd have got specific performance. We wouldn't have been able to resist it.
But I think my lord's point is, this wasn't a matter of controversy before the judge, was it?
No. And, well, it wasn't a matter of controversy once she said that she couldn't order specific performance because there was no planning permission, but she would then award damages. And the only evidence she had as to the assessment of damages was Mr. Gumansingh's report. But as I've pointed out, that assumes planning permission.
And the evidence of permission had been granted. I mean,
But the judge also found it had not been granted.
Yeah, well,
That's the point. Sorry.
I think you're entitled to say the premise on which the judgment was given was that specific performance was not available because planning permission had not been given. Otherwise, specific performance is irresistible, so that there is a contradiction,
Yes.
or at least, how shall I put it neutrally, a tension between
I prefer the word contradiction, but
Yes.
I'll take tension if that is.
Anyway, you have Mr. Nibar's assurance that you're not going to lose both the land and have to pay the.
Well, in many respects, that's a relief. But my lords, my lady, I hope I've addressed those questions,
Yeah,
and
indeed.
in particular the law. But is there any other matter you'd wish my assistance with?
Thank you very much indeed, Mr. Bahari Lal. And we're very grateful to Council, not least for the economy of their presentation, and of course to those who behind the scenes have assisted in the preparation of the written cases. We're very pleased to welcome the team for the respondent on their first visit to the Privy Council, and I hope that they have enjoyed the experience. The court is now adjourned.